But first, we sit down and discuss different types of wills with McMahan Law Firm. Listen, we are down here at McMahan Law Firm. I've got Jay Kennamer joining us right now to talk a little bit about wills, going from a simple will and a whole lot more. You've got kind of a bit of an outline here for us.
Yeah, a lot of people don't know exactly where to go and what to do when they need estate planning or what they're going to do with their children, their assets. And it's really very simple. And you can see from the name itself, it's a simple will. Part of it is simple will, but the other half of the equation would be a power of attorney and a power of attorney for health care, and also a living will.
Let's talk about a simple will. Who qualifies for a simple will?
Just about anybody that is of age can go ahead and make a simple will. Most of the time it's young couples that have children. That's really when they start to worry about who's going to get the kids. You can set up guardians for the kids if something were to happen to both of them at the same time, God forbid. But, and of course later on in life, people start to think more about simple wills. And generally the rule of thumb, if you're going to have a simple will, you really need to have $1 million or less in total property.
Now, the next couple of things here, we got general power of attorney and then power of attorney for health care. How do you explain really what a power of attorney is?
Well, you said the will lets you get letters testamentary, which is really a power of attorney after death. Okay. It only takes place if you're gone. So let's assume someone has a stroke, needs medical care, and they're not dead. The will does nothing for them at that time. The other part of the equation, the full package, should be simple will, but also have a durable power of attorney for general assets, to pay debts, handle real estate, be able to handle anything in the person's, say if you were unable to take care of yourself at the time, someone could take care of you and your financial affairs for you with the power of attorney. The power of attorney for health care is similar. Of course, it's just the power of attorney to make healthcare decisions. You're not able to decide whether you're going to have that surgery, but someone can make that. You designate somebody that beforehand, before you are unable to do so, to make those decisions for you. So it's really taking care of you before death, when you're not able to take care of yourself during that time.
Now, as you mentioned earlier, when we talk about wills, we think about that more or less in the event of a death in the family, but you also have living wills.
Yeah. The last part of the equation, usually in the regular package, when you get a simple will and the two powers of attorney, is a living will. This takes the burden off the surviving family members of having to say, are we going to pull the plug? That is a horrible burden to leave on surviving family members. And people want to really think, would I want to lay there brain dead, accumulating hundreds of thousands of dollars bills a day, when there's no chance, the doctors say that there's no chance to recover. They can determine themselves whether it's going to pull the plug. And that takes the burden off the surviving family members from having to make that decision.
Okay. Why would you not want to write your own will?
Well, there are certain aspects of Tennessee law that make it easier to probate a will, and to also you got to ensure that it's valid. Someone writing their own will with no legal training and it's not valid, you might as well not have one at all, and you're going to have the huge cost of an administration. Probate of a simple will, small. Cost of an administration, big.
Well, we certainly appreciate it. We know how important a will is and how important that document is as well, but we appreciate you explaining a little bit to us and our audience.
All right, thank you.